I'm Margaret Thompson, 75 years old, and until 3 weeks ago, my own children treated me like a doddering old fool who couldn't remember where I put my reading glasses. Mom's losing it. My daughter Sarah would whisper to her brothers when they thought I couldn't hear. We need to start thinking about assisted living. They rolled their eyes when I spoke at family dinners, dismissed my opinions as senior moments, and made jokes about my confusion behind my back. What they didn't know was that I graduated summa cum laude from Harvard Law School in 1972, practiced corporate law for 40 years, and retired with a mind sharper than a surgical scalpel. I let them believe what they wanted to believe. But when Sarah's husband got arrested for embezzlement and faced 20 years in federal prison, suddenly my senile brain became their only hope for salvation. Like and subscribe if you've ever been underestimated by your own family. The phone rang at 3:17 a.m., jarring me from a peaceful sleep. In my 75 years, middle of the night calls had never brought good news. Sarah's voice crackled through the receiver, high-pitched and trembling with panic. Mom, oh God, Mom, you need to come over right now. David's been arrested. The FBI came to our house with a warrant. They have guns, Mom, actual guns. I sat up slowly, my mind instantly alert despite the late hour. Slow down, sweetheart. Tell me exactly what happened. Through her sobs, the story tumbled out. Federal agents had surrounded their suburban home at midnight, presenting an arrest warrant for David Chen, my son-in-law of 12 years. The charges were serious: wire fraud, money laundering, and embezzlement from his prestigious law firm, totaling over $2 million. They're saying he could get 20 years in federal prison. Mom, 20 years. What am I going to tell the kids? How am I going to manage the mortgage, the car payments, everything? I could hear David in the background, his usually confident voice now reduced to desperate pleading on what sounded like multiple phone calls. No, you don't understand. This is a mistake. I didn't steal anything. Check the books again. Sarah, honey, is David still there, or did they take him? They arrested him, but he made bail this morning. His law firm posted it, but they've suspended him indefinitely. The partners won't even take his calls now. Mom, what are we going to do? I'd been observing David for over a decade, watching him at family gatherings with his expensive suits, flashy watch, and constant bragging about his latest luxury purchases. While my children saw success, I'd seen the telltale signs of someone living beyond their means. The way he'd change the subject when asked specific questions about his work, his nervous energy when discussing finances, the slight tremor in his hands when he thought no one was looking. Have you contacted a criminal defense attorney? We called 3 firms this morning. Mom, the retainers alone are $50,000 minimum, And that's just to get started. Good federal defense attorneys charge $800 an hour. We don't have that kind of money, especially not now with David suspended. The irony wasn't lost on me. David worked at one of the city's most prestigious law firms, specializing in white-collar defense. Yet when he needed legal representation for himself, he couldn't afford his own colleagues. What about the public defender? Sarah's laugh was bitter. With federal charges this serious, Mom, public defenders are overworked and underpaid. David says they barely have time to read the case files, let alone mount a proper defense. He needs someone who understands complex financial crimes, someone with experience in federal court. I listened to my daughter's desperation, thinking about the 23 years I'd spent in courtrooms, the countless clients I'd defended, the federal judges who still remembered my name with respect. But Sarah didn't know any of that. To her, I was just Mom, the woman who forgot where she put her car keys and asked the same questions twice. During family dinners, "I'm coming over," I said simply, "Mom, you don't need to drive at night. It's dangerous for someone your age." Someone my age. If she only knew that just 5 years ago, I was still reviewing complex merger agreements and negotiating million-dollar settlements. If she only knew that my mind remained as sharp as the day I graduated from Harvard Law School, that I chose to let them believe I was declining because it was easier than explaining why I'd stepped away from a career that defined me for decades. I'll be there in 20 minutes. As I hung up the phone and reached for my clothes, I couldn't help but smile slightly. After years of being treated like a fragile, confused old woman, life had just presented me with an opportunity to remind my family exactly who Margaret Thompson really was. The arrest warrant sitting on Sarah's kitchen table would change everything. Driving through the empty streets toward Sarah's house, memories flooded back like scenes from a movie I'd forgotten. I'd starred in. The woman my family saw now. The one who supposedly couldn't remember where she put her reading glasses, bore little resemblance to the Margaret Thompson who'd walked across the Harvard Law School graduation stage in 1972. I was only 22. Then, one of just 18 women in a class of 540 students. The legal profession wasn't exactly welcoming to women in those days. Male classmates would make jokes about us taking spots away from real lawyers, and professors would call on us only when they wanted to discuss cases involving rape or divorce, as if those were the only legal matters women could comprehend. But I thrived on the challenge. While my male classmates spent their evenings at bars arguing about sports, I was in the library, mastering constitutional law, memorizing case precedents, and developing the analytical skills that would later make me legendary in corporate litigation circles. My professors noticed. Dean Richardson pulled me aside during my final semester. Margaret, you have one of the finest legal minds I've encountered in 30 years of teaching. The top firms in Boston and New York are asking about you specifically. I chose Morrison, Klein, and Associates in Boston, partly because they offered the highest starting salary, but mostly because they were the only firm that didn't ask me during the interview whether I planned to quit once I got married and had children. That's where I met Robert Thompson. He wasn't a lawyer. He was an architect consulting on a zoning dispute case I was working on. Tall, kind, with gentle hands that could draft building plans with mathematical precision and hold me with surprising tenderness. He'd never been intimidated by my success. If anything, he seemed proud to introduce me as Margaret Thompson, the brilliant attorney who's about to make partner. We married in 1976, when I was 26 and already making a name for myself in complex corporate litigation. I remember our wedding photo, tucked away now in a box in my closet. Robert in his navy suit, me in my grandmother's lace dress. Both of us glowing with the confidence of two people who believed they could conquer the world together. The children came later, Michael in 1978. Sarah in 1980, and James in 1983. Each pregnancy slowed me down professionally, but I always returned to work with renewed determination. I hired the best nannies, worked longer hours when necessary, and somehow managed to excel at both motherhood and my legal career. By 1985, I was the youngest female partner in the firm's history. My specialty was defending corporations against federal regulatory actions, the same type of complex white-collar cases that David now faced from the other side. I'd saved companies millions of dollars, negotiated settlements that kept executives out of prison, and earned the respect of federal judges across New England. The newspaper clipping from 1994 was still in my desk drawer. Boston attorney Margaret Thompson wins landmark federal case. The photo showed me standing on the courthouse steps, briefcase in hand, explaining to reporters how I'd gotten all charges dismissed against a pharmaceutical company accused of FDA violations. But as the children grew older, something shifted. Robert began experiencing chest pains in 1998. The doctors said it was stress. Prescribed medication. Recommended. He slowed down. I found myself leaving work early more often, declining high-profile cases, choosing family over career advancement. When Robert died suddenly of a heart attack in 2003, I realized I'd been preparing for loss without even knowing it. The children were grown by then. Michael finishing his MBA, Sarah working as a marketing manager, James starting his engineering career. They were successful, independent adults who didn't need their mother's constant attention. I could have resumed my aggressive career track. Former colleagues called regularly, offering partnerships at prestigious firms, chances to handle landmark cases that would define my legacy. But grief changes you. The competitive fire that had driven me through law school and early career seemed less important than spending quiet evenings reading, gardening, or simply sitting on my porch watching. The seasons changed, so I stepped back gradually, took on fewer cases, consulted rather than litigated, and eventually retired completely in 2010. The transition was so gradual that even I didn't realize how completely I'd retreated from the professional world that had once defined me. My children, busy with their own careers and families, simply adjusted to this new version of their mother. They remembered me as successful, of course, but the details had faded over time. To them, my legal career became just another part of family history, like Robert's architecture projects or their grandparents' immigration stories. Interesting, but not particularly relevant to their current lives. When I occasionally mentioned legal concepts or current court cases, they'd smile indulgently and change the subject. When I forgot minor details or repeated stories, they'd exchange those meaningful glances that said, "Mom's getting old." It became easier to let them believe what they wanted to believe. Easier than explaining that I missed the intellectual challenge of legal work, but couldn't bear the emotional intensity anymore. Easier than admitting that their successful, confident mother had chosen quiet obscurity over professional recognition. But now, driving toward my daughter's crisis, I felt something awakening that I hadn't felt in years. The thrill of a complex legal challenge, the satisfaction of using my mind to solve problems that seemed impossible to others. David's arrest wasn't just a family crisis. It was an opportunity to remember who I really was. The truth was, I'd been playing a role for so long that sometimes I almost believed it myself. The confused elderly woman who couldn't remember names, who asked the same questions repeatedly, who needed help with technology and modern conveniences. She was as much a performance as any courtroom argument I'd ever delivered. It started innocently enough. After Robert's death, when the children would visit, they'd naturally take charge of small tasks. "Here, Mom, let me help you with that computer. Don't worry about the insurance paperwork. I'll handle it. Are you sure you should be driving?" At night, their concern was touching, and I was genuinely grieving. So I allowed them to help more than I needed. But as months turned to years, their helpfulness evolved into something else, a kind of benevolent condescension that assumed I was incapable rather than simply allowing them to assist. Michael, my eldest, was the worst offender. During family dinners, he'd speak to me the way you might address a child, using simple words and speaking slightly louder than necessary. "Mom, do you remember my colleague Jennifer? I told you about her last week when I'd respond with perfectly coherent answers. He'd nod approvingly, as if I'd just successfully completed a basic cognitive test. Sarah treated me like a beloved but fragile antique. She'd rearrange my furniture for safety, install grab bars in my bathroom without asking, and periodically suggest I might be happier in a senior living community where I'd have more support and social activities. James, my youngest, was the most subtle, but perhaps the most hurtful. He'd simply tune out when I spoke, checking his phone or staring into space with the patient expression of someone waiting for a boring conversation to end. When I'd offer opinions about current events or family decisions, he'd say things like, "That's nice, Mom," in the same tone he used with his 5-year-old daughter. The irony was that my mind remained completely sharp. I read voraciously, legal journals, current events, complex fiction. I stayed current with changes in federal law, followed Supreme Court decisions, and could still analyze complex legal arguments with the same precision that had made me legendary in Boston legal circles, but they saw what they expected to see. When I'd momentarily forget someone's name, something that happens to people of all ages, they'd exchange those knowing looks. When I'd ask them to repeat something because I hadn't heard clearly, they'd speak slower and louder, assuming the problem was cognitive rather than auditory. The most painful part was how they'd discuss me as if I weren't there during family gatherings. They'd retreat to the kitchen or back porch for whispered conversations about Mom's condition. I'd hear fragments. "She's definitely declining. We need to start thinking about power of attorney. Maybe it's time to take away her car keys." Dr. Peterson, my physician of 15 years, was always baffled by their concerns. My annual physicals were perfect, blood pressure excellent, cholesterol levels enviable for someone half my age, cognitive function tests consistently in the 99th percentile. But when I'd mention my children's worries, he'd just shake his head and mutter something about adult children who can't accept their parents aging. The deception became almost a game. I deliberately searched for reading glasses that were sitting on top of my head or ask about appointments I'd already written in my calendar. Not because I was confused, but because it was easier than constantly correcting their assumptions and dealing with their skeptical looks when I demonstrated competence they didn't expect. Sometimes I'd catch myself in the mirror and wonder who I was becoming. The woman staring back at me had the same sharp brown eyes, the same determined jawline that had intimidated opposing counsel for decades. But she was dressed in comfortable cardigans instead of power suits, and she'd learned to make herself smaller, quieter, less formidable. The loneliness was the hardest part. I'd spent 40 years in a profession where my intellect was respected, where colleagues sought my opinions, where judges would listen carefully when I spoke. Now my own children treated my thoughts as the confused ramblings of an elderly woman whose mind was failing. I'd tried to break the pattern a few times. Last Christmas, when Michael was complaining about a legal issue at his company, a contract dispute that was clearly a matter of misinterpreted indemnification clauses, I'd offered my analysis. Actually, honey, the problem isn't the language itself, but the way it's been applied. If you look at the Morrison versus Hartwell precedent from 1987, he'd interrupted me with a patronizing smile. Mom, legal stuff is pretty complicated. Let's just focus on enjoying the holidays. Legal stuff. As if I'd spent for decades playing dress-up in courtrooms instead of building one of the most respected corporate litigation practices in New England. After incidents like that, it became easier to just smile and nod, to let them believe I was the sweet, slightly confused grandmother who baked cookies and watched too much daytime television. It was a safer role, one that didn't challenge their assumptions or force them to reconsider their perception of who I'd become. But tonight, driving through the darkness toward Sarah's crisis, I felt the old fire returning, the intellectual excitement of a complex legal challenge, the satisfaction of using my mind to solve problems that seemed impossible to others. David's arrest had just shattered the comfortable fiction we'd all been living, whether my family was ready or not. They were about to rediscover exactly who Margaret Thompson really was. Sarah's house was blazing with lights when I arrived, every window glowing like a beacon of crisis in the quiet suburban neighborhood. I could see figures moving frantically inside, my daughter pacing back and forth across the living room window. David hunched over the kitchen table with his head in his hands. The front door opened before I could knock. Sarah fell into my arms, her designer pajamas wrinkled and tear-stained, her usually perfect hair disheveled from running her fingers through it repeatedly. "Oh, Mom, thank God you're here. I don't know what we're going to do." David looked up when I entered the kitchen, his face pale and drawn, the confident, slightly arrogant man who'd spent years lecturing me about everything from investment strategies to proper wine selection was gone, replaced by someone who looked genuinely terrified. "Margaret, I'm so sorry you had to come out at this hour. This is all just a terrible misunderstanding." I sat down across from him, noting the stack of legal documents spread across the table. Bank statements, FBI seizure notices, and what appeared to be a copy of the federal indictment, even upside down. I could make out enough legal terminology to understand the scope of the charges. "Tell me exactly what happened, David. Start from the beginning." He looked at Sarah, who nodded encouragingly. The FBI says I embezzled $2.3 million from client trust accounts over the past 3 years. They have bank records, wire transfer documentation, even security footage of me making deposits into personal accounts. I picked up the indictment, scanning the charges methodically: wire fraud, money laundering, violation of fiduciary duty. All federal crimes carrying significant prison sentences. The prosecution had clearly built a comprehensive case. These client accounts were you authorized to access them? Yes, of course. I'm a senior associate at Whitman, Sterling and Associates. Managing client trust funds is part of my job, but I never stole anything, Margaret. Every transfer was legitimate business expenses or authorized client distributions. Sarah sat down beside him, clutching his hand. David handles trust accounts for some of the firm's biggest clients: real estate developers, investment groups, corporate settlements. The amounts are always large. I continued reading, my trained eye catching details that would have escaped my family's notice. The pattern of transfers was sophisticated, small, amounts initially, gradually increasing over time. The money had been moved through multiple accounts before landing in David's personal banking, creating a paper trail that would be difficult to explain away as accidental. David, these transfers show a clear escalation pattern, starting with $5,000 3 years ago, building to transfers of $50,000 or more in recent months. That suggests intentional, systematic embezzlement rather than bookkeeping errors. His face flushed. I can explain every single transfer. The firm's accounting system is antiquated. Sometimes client funds get misallocated, and I have to move money around to balance the books properly. For 3 years, without your supervisors noticing, the senior partners are barely involved in day-to-day operations anymore. They're focused on business development and client relationships. The actual financial management falls to associates like me. I set down the indictment and looked at him directly. David, I need you to be completely honest with me. Did you take money that didn't belong to you? Sarah squeezed his hand tighter. Tell her, honey. Tell her how the firm has been treating you. How they've been setting you up to take the fall for their own problems. David's composure finally cracked. Margaret, I've been working 80-hour weeks for 12 years. I've brought in over $50 million in new business for that firm, and my salary is still less than first-year associates make at comparable firms in Boston or New York. That doesn't answer my question. The money was always intended to be temporary loans when the firm's cash flow was tight, when we needed to cover expenses before client payments came through. I would advance funds from my personal accounts. The transfers you're seeing are me getting reimbursed for legitimate business expenses. I picked up one of the bank statements, running my finger down the columns of figures. David, these statements show money flowing from client accounts to your personal accounts, not the reverse. If you were advancing your own money to cover firm expenses, the transfers would go the other direction. His shoulders sagged. It's complicated, Margaret. The firm's financial structure is unconventional. There are cash flow issues that the senior partners don't want clients to know about. Sometimes client funds have to be moved around to cover operational expenses. Are you saying the firm knew about these transfers? They had to know. Every transaction goes through their accounting department. Every transfer requires approval codes that only senior associates and partners have access to. Sarah leaned forward eagerly. See, Mom, David's being made a scapegoat for the firm's financial problems. They're throwing him under the bus to protect themselves. I studied the documents more carefully, my legal mind automatically organizing the information into patterns, the timing of transfers, the amounts involved, the progression from small to large sums. It all told a story, but not necessarily the one David was telling. Who else at the firm has access to client trust accounts? 3 senior partners and 2 other senior associates. But Margaret, I swear to you, every penny I took was with the understanding that it was legitimate business expense reimbursement. Then, why didn't you report these transactions to the IRS as income? These bank statements show you deposited $2.3 million without declaring it as taxable income. The question hung in the air like smoke. David stared at the table, unable to meet my eyes. Because, he said finally, his voice barely above a whisper, I was planning to put it all back before anyone noticed. I just needed time to get my personal finances sorted out, and there it was, the admission that changed everything. David hadn't been reimbursed for legitimate expenses. He'd taken money he planned to return, which was still theft under federal law, regardless of his intentions. Sarah's face went white. David, what are you saying? I'm saying I made a terrible mistake, and now I'm going to prison for 20 years, unless we can find a way to prove that. The firm's senior partners knew exactly what was happening and approved it. As I sat in that brightly lit kitchen, surrounded by the wreckage of my son-in-law's career and my daughter's security, I felt the familiar thrill of a complex legal challenge. This wasn't just about David's guilt or innocence. It was about whether a larger conspiracy could be proven, whether prosecutorial overreach could be demonstrated, and whether an experienced attorney could find the weaknesses in what appeared to be an airtight federal case. For the first time in years, I had a problem worthy of my skills. By 10 o'clock the next morning, my living room had been transformed into a crisis command center. Michael had driven down from Portland with his wife Jennifer, arriving with coffee and grim expressions. James had caught the first flight from Chicago. His usual easygoing demeanor replaced by the focused intensity he typically reserved for engineering problems. Sarah sat curled in Robert's old armchair, still wearing yesterday's clothes, clutching a mug of coffee like a lifeline. David paced nervously by the window, checking his phone every few minutes for updates from the one attorney who'd agreed to a consultation. I'd spent the early morning hours doing what I always did when facing a complex problem: research. My home office, which my children assumed was just a place where I paid bills and stored old photo albums, actually contained a complete legal library that I'd maintained even after retirement. Federal criminal procedure, white-collar defense, strategies, recent changes in money laundering statutes. I'd refreshed my knowledge of everything relevant to David's case. Okay, Michael said, settling into his take charge mode as the eldest sibling. Let's figure out what we're dealing with here. David, walk us through exactly how much trouble you're in. David stopped pacing and faced the room like a defendant. Addressing a jury, the federal charges carry a maximum sentence of 20 years. The prosecutor is pushing for the full sentence because of the amount involved and the duration of the alleged criminal activity. Alleged? James raised an eyebrow. I thought you admitted last night that you took the money. I admitted that I moved money around to cover cash flow problems. That's very different from theft or embezzlement. Jennifer, who worked as a financial analyst, had been quietly reviewing the documents David had brought. These bank records are pretty damning. David, the pattern shows systematic transfers from client accounts to your personal accounts over 3 years. That's going to be difficult to explain as anything other than intentional theft. That's why we need the best criminal defense attorney we can find, Sarah said desperately. Someone who specializes in federal white-collar cases. Someone who understands complex financial crimes. Michael pulled out his tablet. I've been researching firms all morning. Thompson and Associates in Boston has an excellent reputation for federal defense work. Their retainer is $75,000, and they estimate the total cost could reach $300,000 or more. If the case goes to trial, the room fell silent. $300,000 might as well have been $3 million for a family facing the loss of their primary income. What about the public defender? James asked. David shook his head. I spoke with the federal public defender's office yesterday. They're handling over 200 active cases per attorney. They recommended I find private counsel, if at all possible, especially given the complexity of financial crimes prosecution. There has to be another option, Sarah said, her voice breaking. What about legal aid societies or pro bono programs? Pro bono attorneys typically handle death penalty cases or civil rights issues, Michael explained. White-collar criminal defense isn't considered a public service priority. I sat quietly in my corner chair, observing the family dynamic I'd watched play out for decades. Michael assuming leadership, James providing practical analysis, Sarah appealing to emotions, and David trying to maintain dignity while his world collapsed around him. What struck me most was how none of them had even considered that there might be legal expertise already present in the room. We could try to negotiate a payment plan with one of the private firms, Jennifer suggested. Maybe offer to pay the retainer in installments. With what? Sarah's laugh was bitter. David's been suspended without pay. Our savings account has maybe $15,000. We're going to struggle to make the mortgage payment next month, let alone hire an expensive attorney. David slumped onto the couch. Maybe I should just plead guilty and hope for a reduced sentence. Accept responsibility. Show remorse. Hope the judge takes mercy on a first-time offender. That's giving up, Michael protested. There has to be a defense strategy. I'm saying that everything your family has been discussing this morning. Prosecutorial strategy, federal sentencing guidelines, defense against financial crimes charges. These are areas where I have considerable expertise. Sarah shook her head slowly. But, Mom, you never told us. All these years, we thought. You thought I was a secretary or a clerk. I know. It was easier to let you believe that than to explain why I'd stepped away from a career that once defined my entire identity. Michael was still studying the newspaper clipping. It says here you were a partner at Morrison, Klein and Associates. That's one of the most prestigious firms in Boston. It was. I spent 28 years there, building one of the most successful corporate defense practices in New England. I argued cases before federal appellate courts, defended Fortune 500 companies against SEC investigations, and yes, I handled numerous cases involving allegations of financial crimes, very similar to what David is facing. The room seemed to tilt on its axis as my family tried to reconcile this new information with their understanding of who I was. I could see them replaying years of interactions, remembering times when they dismissed my opinions or spoken to me like a child. Mom, Sarah said, her voice filled with a mixture of awe and embarrassment. When we were talking about legal issues, when you tried to offer advice, we thought. You thought I was confused. I know, sweetheart, and I let you think that because it was less complicated than explaining that I'd chosen to retire from a world that had consumed my life for 4 decades. David suddenly crossed the room and knelt in front of my chair. Margaret, could you help me? I mean, would you consider representing me? The question hung in the air like a challenge. Everything I'd spent the last 15 years trying to leave behind, the pressure, the responsibility. The emotional intensity of having someone's freedom depend on my skills was being offered back to me. David, I've been out of practice for 15 years. Federal criminal procedure has evolved. New precedents have been established. Technology has changed how evidence is gathered and presented, but you understand the fundamentals. He pressed. You know how federal prosecutors think, how to challenge their evidence, how to build a defense strategy. James leaned forward. Mom, are you seriously considering this? I looked around the room at my family, really looked at them, and saw something I hadn't seen in years. They were looking at me with respect, with hope, with the recognition that I might actually be capable of solving their most serious problem. I would need to research current federal criminal procedure. I would need to update my knowledge of recent case law. I would need to study the specific statutes under which David has been charged. But you could do it, Sarah asked eagerly. I could do it. The words came out more confidently than I'd expected. But there would be conditions. Anything, David said immediately. First, complete honesty. No more stories about legitimate business expenses or misunderstanding. I need to know exactly what you did, when you did it, and why you did it. David's face flushed, but he nodded, agreed. Second, you follow my legal strategy without question. If I tell you to accept a plea bargain, you accept it. If I tell you, we're going to trial, we go to trial. My legal judgment is not subject to family consensus. Understood. Third, this family stops treating me like a confused elderly woman who can't remember where she put her glasses. If I'm competent enough to handle a federal criminal case, I'm competent enough to participate in normal adult conversations without being patronized. The embarrassment on my children's faces was painful to watch, but necessary. They needed to understand that their perception of me had consequences beyond hurt feelings. Mom, Michael said quietly, I'm so sorry. We had no idea. You had no idea because you never asked. You saw what you expected to see, an aging mother whose best days were behind her. But David's case isn't about the past. It's about whether we can use everything I learned in 40 years of practice to keep him out of federal prison. I stood up and walked to my desk, pulling out a legal pad and pen. Now, David, sit down and tell me everything, and I mean everything, because as of this moment, I'm not just your mother-in-law anymore. I'm your attorney. For the first time in 15 years, I felt like myself again. The initial shock of my revelation began wearing off by evening, replaced by something I hadn't anticipated, skepticism. While Sarah remained cautiously optimistic, I could see doubt creeping into the faces of my other children. As the reality of the situation settled in, Michael was the first to voice concerns. approaching me privately while David and Sarah were putting their children to bed. Mom, I need to ask you something, and I hope you won't take it the wrong way. Go ahead, honey. Are you sure you're up for this? I mean, federal criminal defense is incredibly complex, and you've been retired for 15 years. The legal system has changed dramatically since you practiced. Computer evidence, digital forensics, new precedents. I could hear the careful diplomacy in his voice, the same tone he'd used when suggesting I might want to consider giving up night driving. You're wondering if my mind is sharp enough to handle a case this serious. I'm wondering if it's fair to David to risk his freedom on someone who might not be current with modern legal practice. The sting of his words was softened only by the recognition that his concern came from genuine love. Michael, yesterday you thought I couldn't remember where I put my car keys. Today you're worried I can't handle complex litigation. Which version of your mother do you think is real? That's not fair, Mom. We're talking about 20 years in federal prison. This isn't the time for family pride or proving points about how we've treated you. David emerged from the hallway, having overheard our conversation. Michael, with all due respect, your mother is the only chance I have. Do you know how much the attorneys we consulted today want as a retainer? $75,000. Money we don't have and can't borrow. There might be other options. Legal aid societies, law school clinics, attorneys willing to work pro bono. I've researched all of those, David replied. Law school clinics don't handle federal criminal cases. Pro bono attorneys in white-collar defense are essentially non-existent, and legal aid societies are overwhelmed with death penalty cases and civil rights issues. James joined us, carrying 2 cups of coffee. I've been thinking about this all day, and I have to agree with Michael. Mom, no disrespect intended, but this seems like a huge risk. What kind of risk? I asked. The risk that you might miss something crucial because you're not familiar with current practice. The risk that the prosecutor will take advantage of your age and time away from practice. The risk that David ends up worse off than if he'd hired a current practitioner. I studied my son's faces, seeing genuine concern mixed with the same protective instincts that had led them to treat me like a fragile elderly woman. They weren't trying to hurt me. They were trying to protect both David and me from what they saw as an impossible situation. Let me ask you something, I said. When you have a complex engineering problem at work, James, do you throw out everything you learned in college because it's old knowledge? That's different. Engineering principles don't change the way legal precedents do. Actually, they do. New materials, new technologies, new safety regulations, but you adapt your fundamental knowledge to incorporate new information. You don't start from scratch every time. I walked to my bookshelf and pulled down 3 recent volumes. Federal Criminal Procedure, 2023 edition. White Collar Criminal Law, latest supplement. Federal Sentencing Guidelines, current version. I've been studying all afternoon, updating my knowledge of changes since I retired. David looked relieved, but Michael remained skeptical. Mom, reading about recent changes isn't the same as actual courtroom experience with current prosecutors and judges. You're absolutely right. But what current experience does David have with federal criminal defense? What expertise do any of U.S. have in this area, besides what I bring to the table? We could find someone with current experience if we tried harder, James suggested. Maybe contact the State Bar Association for referrals to attorneys willing to work for reduced fees. I felt my patience beginning to fray. For decades, I'd commanded respect in courtrooms, earned the trust of judges, and built a reputation that made opposing attorneys approach settlement negotiations seriously. Now my own children were debating whether I was competent enough to help save their brother-in-law's freedom. David, I said, come here for a moment. He approached, looking nervous about being caught between family loyalties and his desperate need for legal representation. I want you to understand something clearly. If you decide to accept my representation, you're not getting a discount attorney or a well-meaning amateur. You're getting someone who spent for decades mastering federal criminal defense. Someone who never lost a case involving financial crimes. Someone who knows how prosecutors think, because I've beaten them in court more times than I can count. I pulled out a folder I'd been organizing all afternoon. These are summaries of 12 cases I handled between 1985 and 2008, involving charges similar to yours: embezzlement, wire fraud, money laundering, violation of fiduciary duty. In 11 of those cases, I got the charges dismissed or reduced to misdemeanors. In the 12th case, my client received 2 years probation instead of the 15-year sentence the prosecutor was demanding. David's eyes widened as he flipped through the case summaries. You handled the Morrison Savings Bank case. I studied that in law school. The defense strategy was considered brilliant. I developed that strategy. The precedent we established is still cited in federal appeals courts today. Michael and James exchanged glances, beginning to realize that their mother's legal reputation might have been more significant than they'd understood. But Mom, Sarah said, entering the conversation, even if you take David's case, won't the prosecutor assume you're not a serious threat? Won't they underestimate you because of your age? For the first time all day, I smiled genuinely. Sarah, sweetheart, prosecutors underestimating me is exactly what I'm counting on. There's nothing more dangerous in a courtroom than an opponent who thinks you're not worth taking seriously. I closed the folder and looked directly at David. The question isn't whether I'm capable of representing you effectively. The question is whether you're prepared to trust someone who's been consistently underestimated by her own family for the past 15 years. David didn't hesitate. Margaret, if you're willing to take my case, I would be honored to have you. As my attorney, I turn to my children, and if any of you have continued doubts about my competence, you're welcome to observe when I start dismantling the prosecution's case piece by piece. The room fell silent as the weight of my words settled over everyone. After years of being treated like a confused elderly woman, I was finally going to have the opportunity to remind my family and myself exactly who Margaret Thompson really was the next morning. I did something I hadn't done in 15 years. I dressed for court. Not that we were going to court yet, but putting on my navy blue suit. The one I'd worn to closing arguments in some of my most important cases. Felt like putting on armor. The woman who looked back at me from the bedroom mirror bore little resemblance to the confused grandmother my family had been protecting for the past decade. I arrived at David and Sarah's house at 8 o'clock sharp, carrying my old briefcase and a stack of legal documents I'd prepared overnight. David answered the door still in his pajamas, looking like he hadn't slept. "Good morning, counselor," I said, and watched his face transform as the reality of our new relationship settled in. "Margaret, I can't tell you how grateful. Save the gratitude until after I've kept you out of prison. Right now, we have work to do." I set up my temporary office at their dining room table, spreading out copies of the federal indictment, bank records, and a timeline I'd constructed based on David's admissions. Sarah brought coffee and then retreated to give us privacy, understanding instinctively that what was about to happen required attorney-client confidentiality. "David, before we go any further, I need you to sign these documents." I pushed a retainer agreement across the table. "This establishes our attorney-client relationship formally. It also specifies my fee structure." He looked puzzled. "Fee structure? Margaret, we can't afford. My fee is $1, payable upon successful resolution of your case. But there are conditions attached to my representation that are more valuable than money." I pulled out a second document. "This is a behavioral contract. If I'm going to risk my professional reputation coming out of retirement for your case, you're going to follow certain rules." David read through the contract, his eyebrows rising with each clause. "No contact with media without your approval. No discussion of case details with family members except in your presence. Complete honesty about all financial transactions. Immediate disclosure of any new information relevant to the case. Those are standard requirements for any client in a high-stakes federal case. But this next section is specific to our family. situation. He continued reading. Respectful treatment of counsel in all interactions. Recognition of counsel's authority in all legal decisions. No attempts to involve other family members in legal strategy discussions. David, for the past 12 years, you've treated me like an elderly woman whose opinions don't matter. You've interrupted me at family dinners, corrected my statements about current events, and generally acted like my thoughts weren't worth serious consideration. That changes today. His face flushed with embarrassment. Walsh's office was modern and sterile, decorated with law school diplomas, commendation letters, and photographs of her with various political figures. She was younger than I'd expected, probably mid-30s, with the sharp-eyed intensity of someone who'd never experienced professional failure. Mrs. Thompson, I have to admit I was surprised to see your notice of appearance. I thought you'd been retired for years. I was, but my son-in-law's case presented certain compelling circumstances. She smiled with the confident condescension I'd encountered from younger attorneys. Throughout my career, I appreciate family loyalty, but federal criminal defense is quite specialized. Your client might be better served by counsel with current experience in white-collar cases. Ms. Walsh, I've been handling white-collar criminal defense since before you were born. I think I can manage. Of course. Well, I should let you know that we're prepared to offer your client a plea agreement, 10 years in federal prison, with possibility of parole after 7 years, in exchange for full restitution and cooperation in our ongoing investigation of his firm. 10 years. The offer was harsh, but not unexpected for someone facing charges carrying a maximum 20-year sentence. But something in Walsh's eagerness to discuss plea negotiations told me she wasn't as confident in her case as she wanted to appear. That's generous of you, but we'll be proceeding to trial. Her eyebrows rose slightly. Mrs. Thompson, perhaps you should review the evidence before making that decision. We have bank records, wire transfer documentation, security footage, and your client's own admissions. This is not a case where reasonable doubt is a viable strategy. I opened my briefcase and pulled out a copy of my discovery motion. I think you'll find our defense strategy quite firm, but they've always operated on thin margins. The partners draw huge salaries, maintain expensive offices, and spend money on client entertainment like it's going out of style. But client payments are often delayed. Settlements take months to finalize, and there are always cash flow gaps. How did the firm handle those cash flow problems? Sandra glanced around the coffee shop, then leaned closer. The same way David handled them. Senior associates and partners would borrow from client trust accounts to cover operational expenses, then replace the money when client payments came through. How long had this been going on? Ever since I started working there 20 years ago. It was never discussed openly, but everyone knew. The monthly reconciliation reports always showed temporary discrepancies that would resolve themselves within a few weeks. I pulled out a legal pad and began taking notes. Did the partners explicitly authorize these transfers? Not explicitly, but they had to know. Every transfer requires approval codes that only senior staff have. The accounting software generates reports showing all trust account activity, and the partners review financial statements monthly. Were you ever instructed to ignore or hide these temporary transfers? Sandra hesitated, then nodded. Thomas Whitman, the managing partner, told me several years ago that cash flow management was a normal part of law firm operations, and that I shouldn't worry about temporary account discrepancies as long as they were resolved quickly. This was exactly what I'd hoped to find, evidence that the firm's senior partners were aware of and had implicitly authorized the financial practices that led to David's charges. Sandra, would you be willing to testify about these conversations and practices? Her face went pale. I can't testify against my employers. They'd fire me immediately, and I'd never work in another law firm in Boston. What if I told you that David is facing 20 years in federal prison for following practices that were standard at your firm? I feel terrible about that, but I can't risk my own livelihood. I understood her position, but I needed her testimony to establish David's defense. Sandra, what if there were a way to protect your employment while still telling the truth about what you witnessed? I don't understand. If David's defense successfully demonstrates that these financial practices were systemic at Whitman, Sterling, the firm itself could face federal investigation. Your testimony could actually protect you by establishing that you were following orders from senior partners. She considered this, but still looked skeptical. I need to think about it, of course. But Sandra, I want you to consider something else. How many other associates at your firm have handled client trust accounts the same way David did? 3 or 4, at least. And if the government decides to make examples of white-collar criminals, how long do you think it will be before they start investigating those other associates? Wouldn't you rather be part of the solution than waiting to become the next target? I left the coffee shop with Sandra's promise to consider cooperation, but I knew I needed more evidence to build a compelling case. My next stop was the Massachusetts Bar Association's disciplinary office, where I requested copies of any complaints or inquiries regarding Whitman, Sterling and Associates Trust Account Management. The disciplinary counsel, an old colleague named Robert Chen, no relation to David, greeted me with genuine warmth. Margaret Thompson, I heard rumors you were coming out of retirement. What brings you back to the trenches? Family business, Robert. I'm representing my son-in-law in a federal case, and I need to research any disciplinary history for his former firm. Robert's expression grew serious. Whitman, Sterling, interesting timing. We've been conducting a preliminary investigation into their trust account practices for the past 6 months. My heart jumped. What kind of investigation? We received complaints from 3 different clients about delays in receiving settlement funds. When we started examining their trust account records, we found a pattern of temporary transfers that raised some red flags. What did you find? Systematic borrowing from client trust accounts to cover operational expenses. Technically not theft if the money is replaced quickly, but it violates Massachusetts professional conduct rules regarding client fund management. Has the firm been sanctioned? Not yet. We're still gathering evidence. But Margaret, if your son-in-law was following established firm practices, that's highly relevant to our investigation. I felt pieces of the puzzle clicking into place. Robert, would the Bar Association be willing to provide records of this investigation to assist in a criminal defense case, if it's relevant to proving a pattern of firm-wide misconduct rather than individual criminal behavior? I think we could work something out. I spent the next 2 hours reviewing Bar Association files that painted a picture of systemic financial mismanagement at Whitman, Sterling, and Associates. Client complaints, accounting irregularities, and warning letters from bank officials all supported the theory that David's actions were part of a larger pattern of questionable but accepted practices. That evening, I returned to David and Sarah's house with more evidence than I dared hope for. The family was gathered in the living room. David, Sarah, and all 3 of my children, who'd driven down to hear about my progress. What did you find? David asked immediately. I found that you were telling the truth about firm practices. Sandra Martinez confirmed that temporary transfers from trust accounts were standard operating procedure at your firm. The Massachusetts Bar Association has been investigating the same practices for 6 months, and I have documentation showing that senior partners were aware of and approved these financial management techniques. Sarah's face lit up with hope. Does this mean the charges will be dropped? It means we have a viable defense strategy. We can argue that David reasonably believed his actions were authorized based on established firm practices and management approval. Michael leaned forward. Mom, this is incredible work. In just 2 days, you've uncovered more evidence than the federal investigation bothered to find. That's because the federal investigation was focused on building a case against David specifically, not understanding the broader context of law firm financial practices. James shook his head in amazement. I can't believe we ever doubted your abilities. You're dismantling this case piece by piece. I felt a warmth spread through my chest that had nothing to do with legal victory and everything to do with family recognition. For years, They'd treated my opinions as the confused thoughts of an aging mind. Now they were seeing the analytical skills and strategic thinking that had made me successful for decades. David, I need you to prepare for the possibility that this case could expand beyond your individual charges. If we successfully demonstrate that Whitman Sterling's financial practices were systemic, the federal government might decide to investigate the entire firm. What does that mean for me? It means you might go from being the primary target to being a witness in a larger case. It means your cooperation could become valuable enough to warrant significant charge reductions or complete immunity. David's eyes widened. You really think that's possible? I think Prosecutor Walsh is about to discover that her simple embezzlement case has opened a door to a much larger investigation of law firm financial misconduct, and I think she's going to be very interested in making a deal that allows her to pursue the bigger fish. As I packed up my files that evening, I realized that I wasn't just defending David anymore. I was exposing a systemic problem that could impact multiple law firms and change how the legal profession handled client trust accounts. Margaret Thompson wasn't just back in practice. She was back to changing the law itself. The breakthrough came at 2 o'clock in the morning on a rainy Thursday, 3 weeks into my investigation. I was sitting in my home office, surrounded by bankers' boxes full of documents we'd obtained through discovery, when I found the email that changed everything. It was buried in a string of routine administrative communications between Thomas Whitman, the managing partner, and the firm's accountant. The subject line read Q3 cash flow projections, but the content was far more revealing than typical financial planning. Johnny Whitman had written, "We need to be more strategic about managing temporary fund transfers. The September client settlements won't arrive until October 15th. But we have payroll and operational expenses due September 30th. Please coordinate with David and Tom Bradley to ensure adequate liquidity through creative account management." Creative account management, in law firm parlance, that was code for borrowing from client trust accounts. But it was Jean Wong's response that made my hands tremble with excitement. "Thomas, I've prepared a schedule showing available client balances and suggested transfer amounts. David has been handling these arrangements very professionally. His attention to documentation and repayment timelines has been excellent." I read the email 3 times before the full implications sank in. This wasn't David acting independently. This was David following explicit instructions from firm management, with the knowledge and approval of the firm's accountant. I immediately called David. Despite the late hour, he answered on the first ring, sounding wide awake. "Margaret, did something happen?" "David, I need you to come to my house right now and bring Sarah. I've found something that changes everything. Within 30 minutes, they were sitting in my living room while I spread out the email chain on my coffee table. David's face went from confusion to amazement to something approaching relief as he read through the communications. "This proves they knew," he said quietly. "This proves everything I told you about following firm procedures. It proves more than that." I replied, "It proves systematic coordination of trust account borrowing with management approval. Look at this follow-up email from 2 weeks later." I showed them Jeanne Wong's message to Whitman. "All temporary transfers completed successfully. Client funds returned with appropriate interest calculations." David's management of the September cash flow crisis was exemplary. Sarah looked between us, struggling to understand the legal implications. "What does this mean exactly?" "It means David wasn't embezzling money for personal gain. He was managing cash flow crises on behalf of the firm with explicit approval from senior partners following established procedures that had been in place for years." I pulled out another document. "And this partnership agreement from 2019 shows something even more interesting. Look at Section 12, subsection 4. David read aloud. "Senior associates are authorized to make temporary fund transfers between client accounts and operational accounts as necessary to maintain firm liquidity, provided such transfers are documented and resolved within 90 days. They actually put it in writing." Sarah whispered. "They gave David permission to do exactly what he's being prosecuted for. More than permission." I corrected. "They made it part of his job responsibilities, and according to these bank records, every transfer David made was resolved within the 90-day limit specified in the partnership agreement." I showed them a spreadsheet I'd created tracking all of David's transfers against firm cash flow needs. Every single embezzlement corresponds to a documented cash flow crisis. Every transfer was repaid with interest when client settlements arrived, and every action was consistent with written firm policy. David shook his head in disbelief. "Why didn't the FBI find this evidence?" "Because they weren't looking for it. Federal investigators focused on your personal bank accounts and assumed any money flowing into them represented theft. They never examined whether your actions were authorized by firm policy or necessary for legitimate business purposes." I gathered the documents into a neat stack. "David, I'm going to file an emergency motion tomorrow morning demanding that all charges be dismissed based on newly discovered exculpatory evidence. Do you think it will work?" I think Prosecutor Walsh is going to be very unhappy when she realizes her star case just became an embarrassment for the U.S. Attorney's Office. The next morning, I arrived at the courthouse carrying what I considered the most devastating motion I'd filed in 40 years of practice. 27 pages of meticulously documented evidence proving that David Chen had been prosecuted for following explicit firm policies, not for committing federal crimes. Judge Patricia Morrison, who'd presided over several of my cases in the 1990s, seemed surprised to see me back in her courtroom. Miss Thompson, I understand you're representing Mr. Chen. It's good to see you practicing again. Thank you, Your Honor. I'm here to present newly discovered evidence that I believe requires immediate dismissal of all charges against my client. Prosecutor Walsh stood up, looking considerably less confident than she had during our first meeting. Your Honor, the government objects to any last-minute motions based on Ms. Walsh. Judge Morrison interrupted. Have you reviewed the defense motion? Yes, Your Honor. But we believe the evidence cited is not relevant to the specific charges. Actually, Ms. Walsh, I'd like to hear what Ms. Thompson has discovered in 40 years of practice. I've never known her to waste the court's time with frivolous motions. I approached the podium with the confidence that came from knowing I held winning cards. Your Honor, the government has prosecuted my client for embezzlement and wire fraud based on transfers from client trust accounts. However, newly discovered evidence proves these transfers were explicitly authorized by firm policy and required by cash flow management needs. I presented the email exchanges, the partnership agreement, and the financial documentation showing the relationship between David's transfers and firm operational requirements. Furthermore, Your Honor, every transfer was repaid with interest within the time limit specified in firm policy. My client was not enriching himself at client expense. He was performing cash flow management duties assigned to him by firm management. Judge Morrison reviewed the documents carefully. Ms. Walsh, did the government investigate whether Mr. Chen's actions were authorized by firm policy? Walsh's discomfort was obvious, Your Honor. The defendant's personal financial gain was clear evidence of criminal intent. What personal financial gain? I interrupted. Every penny my client transferred was returned to client accounts with appropriate interest. His personal bank accounts show no permanent increase in assets. Where exactly is the evidence of personal enrichment? The courtroom fell silent as Judge Morrison continued reading. After what felt like an eternity, she looked up. Ms. Walsh, this evidence raises serious questions about whether Mr. Chen's actions constituted crimes at all. If he was following explicit firm policies with management approval, how does the government prove criminal intent? Your Honor, we believe Ms. Walsh. I'm not asking what you believe. I'm asking what evidence you have that Mr. Chen intended to permanently deprive clients of their funds when firm policy explicitly authorized temporary transfers for operational purposes. Walsh had no answer, and we all knew it. Your Honor, I said, I request that all charges be dismissed immediately based on lack of evidence of criminal intent. Alternatively, I request that the government be ordered to produce all evidence of Mr. Chen's criminal intent that doesn't rely on actions explicitly authorized by his employer. Judge Morrison closed the file. Ms. Walsh, I'm giving the government 2 weeks to respond to this motion with substantial evidence of criminal intent, or I will grant the defense motion to dismiss. This case appears to be based on a fundamental misunderstanding of the defendant's authorized duties. As we left the courthouse, David was practically vibrating with excitement. Margaret, you did it. You actually did it. We haven't won yet, but we've certainly put the government in an impossible position. They either have to admit their case was flawed from the beginning, or produce evidence they don't have. As I walked to my car, I felt the satisfaction that came from executing a perfect legal strategy. Jennifer Walsh had learned that underestimating a 75-year-old attorney was a career-limiting mistake. More importantly, my family had learned that Margaret Thompson's mind was as sharp as ever. The 2 weeks following my motion felt like an eternity, but I used every minute to strengthen our position. If Judge Morrison didn't grant our dismissal motion, I wanted to be prepared for the most aggressive defense strategy of my career. My dining room table had become a war room, covered with legal briefs, case precedents, and witness statements. Sarah had taken over as my unofficial paralegal, organizing documents with the efficiency of someone whose husband's freedom depended on perfect preparation. Even my other children had begun stopping by regularly, no longer to check on my well-being, but to witness what they now recognized as legal brilliance in action. Mom, Michael said during one of his visits, I have to ask, is this what you were like when you practiced full-time? This level of intensity and preparation. I looked up from the Supreme Court decision I was analyzing. This is what it takes to win impossible cases, honey. You don't beat federal prosecutors with half measures. The centerpiece of our strategy was a motion to dismiss based on prosecutorial misconduct. During my research, I discovered that the FBI's investigation had been remarkably narrow, focusing exclusively on David's personal finances while ignoring obvious evidence of firm-wide practices. Look at this, I told David, showing him the FBI's investigative report. They interviewed you, examined your bank records, and traced your financial transfers. But they never interviewed Sandra Martinez, never examined firm policies, never requested partnership agreements. This wasn't a thorough investigation. It was a targeted prosecution. David studied the report. You're saying they decided I was guilty and then looked for evidence to support that conclusion? I'm saying they built a case around the assumption that any money flowing from client accounts to an associate's personal account represented theft. They never considered whether those transfers might be authorized or necessary for legitimate business purposes. I'd also been working on something that would have been impossible 15 years ago. A digital forensics analysis of the firm's electronic communications. My grandson Tommy, James's eldest son, who worked in computer security, had taught me how to search through thousands of emails and documents for relevant keywords and patterns. Grandma, you're like a legal detective, Tommy had said after helping me set up the search protocols. I had no idea lawyers did this kind of investigation. The digital search had revealed a treasure trove of evidence. Email exchanges showing that cash flow management was a constant concern at Whitman Sterling. Financial planning documents that explicitly anticipated using client trust funds for operational expenses, even training materials for new associates that included instructions on proper procedures for temporary fund transfers. But my most powerful weapon was Sandra Martinez. After 2 weeks of careful persuasion, she'd finally agreed to provide a sworn affidavit detailing the firm's financial practices. Her statement was devastating to the prosecution's case. Sandra Martinez, office manager at Whitman Sterling and Associates for 20 years, hereby state that temporary transfers from client trust accounts to cover operational expenses were standard practice at our firm. These transfers were not secretive or unauthorized. They were necessary business operations that were discussed openly in staff meetings and documented in monthly financial reports. Her affidavit went on to detail specific conversations with senior partners about cash flow management, training sessions for associates on proper transfer procedures, and her own role in facilitating these financial arrangements. Sandra's testimony destroys the government's theory of the case. I explained to David, they can't argue that you were acting secretly or criminally when your actions were part of established firm policy known to and approved by management. I'd also prepared something that I hoped wouldn't be necessary, but wanted available if the case went to trial. Character witnesses who could testify to David's integrity and professional competence. Clients who'd been satisfied with his work. Colleagues who'd witnessed his careful attention to financial documentation. Even opposing counsel who'd found him honest and reliable in negotiations. The government wants to portray you as a greedy criminal who stole client money for personal enrichment. I told him, we're going to show the jury a dedicated attorney who was following firm policy to ensure his colleagues got paid and client services continued uninterrupted. On the Thursday, before the government's response was due, I received an unexpected phone call from Jennifer Walsh, Ms. Thompson. I was wondering if we could meet to discuss possible resolution of Mr. Chen's case. I'm listening. Would your client be interested in pleading to a single misdemeanor charge with time served and probation? No restitution required, since the evidence shows no permanent client losses. I felt a surge of victory. The prosecutor, who'd initially demanded a 20-year sentence, was now offering essentially a slap on the wrist. That's quite a change from your original position, Ms. Walsh. Our review of the additional evidence has clarified certain aspects of the case. I'll discuss it with my client, but I think we'll decline. We believe the evidence supports complete dismissal of all charges. Ms. Thompson, please consider this carefully. Even with the new evidence, a federal jury might still find criminal intent. A guaranteed misdemeanor conviction might be preferable to the risk of felony convictions at trial. After I hung up, I called David immediately. The government just offered you a misdemeanor plea with probation and no restitution. That's incredible. So we won? Not yet. They're offering this because they know their case is falling apart, but they don't want to admit it publicly. A plea bargain lets them save face, while you avoid any significant punishment. Should I take it? That's your decision, David, but I want you to understand something. I believe we can get all charges dismissed if we proceed with our motion. The question is whether you want guaranteed resolution now or complete vindication later. David was quiet for a long moment. Margaret, what would you do if this were your case? I'd fight. I'd make them admit they prosecuted an innocent man for following his employer's policies. I'd make sure this never happens to another attorney who gets caught in their firm's cash flow problems. Then that's what we'll do. The following Monday, I was back in Judge Morrison's courtroom for the government's response to our dismissal motion. Jennifer Walsh looked like she'd aged 5 years in 2 weeks. Your Honor, she began, while the government acknowledges that certain firm policies may have created ambiguity about authorization for the defendant's actions, we maintain that the scale and duration of the transfers demonstrate criminal intent. Judge Morrison looked skeptical. Ms. Walsh, what evidence do you have of criminal intent when the defendant's actions were explicitly authorized by firm policy and all funds were returned with interest? The defendant failed to report these transfers as income, suggesting an intent to conceal. Ms. Thompson, Judge Morrison invited my response. Your Honor, my client had no obligation to report temporary cash advances as income when firm policy required their return. The accounting was handled by the firm's financial department, and all transfers were properly documented in firm records. I approached the bench with a final piece of evidence I'd been saving. Your Honor, I'd like to present Exhibit 17, a memo from the firm's accountant to the IRS explaining why these transfers were not reported as associate income. The firm's own tax advisor confirmed that temporary operational advances are not taxable events. Judge Morrison reviewed the memo, then looked at Walsh with something approaching irritation. Ms. Walsh, it appears the government has prosecuted Mr. Chen for actions that his employer explicitly authorized that were necessary for legitimate business purposes and that were properly handled under applicable tax law. What exactly is the criminal conduct here? Walsh had no answer because there wasn't one.